Jim, a little bit earlier, you felt very strongly that the state has made the case for all of the offenses here. Now you've got someone, and you have a certain perspective, having handled a lot of these cases yourself. You've got someone who's handled the other side of these types of cases, feeling strongly that their intent has not been proven. And so, how do you think that this falls in the jury? People who are not exposed to either side, do you think they end up coming back with perhaps the third-degree murder charge or manslaughter?
Well, it speaks to how difficult these cases are. This gentleman says that he's never lost a case. I prosecute these cases in a civil forum, which we have a different standard, but he has the intent wrong. I mean, you don't need to prove that Derek Chauvin intended to kill George Floyd. You don't need to prove that he intended even to cause him great bodily harm. And the jury instructions clearly say that. You do have to prove that he intended the force, the knee on the neck, that did cause bodily harm and did cause harm to an organ, the brain, the lungs, the heart. All of that is included within the jury instructions as to, in terms of great bodily harm to an organ of Mr. Floyd, that the force has to have affected in order to find guilty on that second-degree murder charge. So, and again, for the third degree, now they've made it clear it has to be reckless disregard of his life. So if you could have the disregard of his life for a manslaughter charge, the third-degree murder charge is there as well. So again, when you look at the use of force instructions too, it's not necessary to put your knee on his neck. It's not.
Right.
You could put it if it's not necessary, it's not reasonable, it's unlawful force, guilty.